welcome to our next in our series of frequently asked questions. I'm speaking to Neil Graham, who is a partner at our firm today, and we'll be discussing prenuptial agreements. We have some questions here that might be useful to you, and Neil is hopefully going to answer them for us today. So to kick things off, we have a question here, which is, what are the benefits of having a prenuptial agreement, and why might a couple consider having one?
Thank you, Sarah, for asking that. It's a good question. When people get married, they are always concerned about their wedding venue and their honeymoon, what they're going to wear, what the food is going to be like, what the reception is going to be like, what the ceremony is going to be like. But people often forget to think about a prenuptial agreement. And there are benefits to prenuptial agreements, as we're going to discover in a minute. Although agreements aren't automatically fully enforceable under English law, they are a very good opportunity to agree in advance how things might be divided financially, with how capital and income claims might be dealt with in the unlikely event that the marriage doesn't last. Of course, nobody goes into a marriage expecting it not to last, and we all do hope that our relationships last a lifetime. But it is sensible to try to provide for what might happen in the very unlikely event that your relationship doesn't last. So the main benefits of a prenuptial agreement are agreeing up front what would happen in that unlikely event, so that you don't have the acrimony, the heartache, and the considerable legal cost of trying to divide your capital assets and sort out your income claims in the future if your relationship sadly doesn't last.
Okay, thank you very much. Our second question is, how common are prenuptial agreements?
That's a good question. Historically, prenuptial agreements were very rare, and in fact, historically, they were thought of as being contrary to public policy. But things have changed gradually over the years, and they are now very commonplace. And even though they're not automatically and completely fully enforceable, it is now very common for people to enter into prenuptial agreements. You can enter into an agreement obviously before you get married, or you can do a prenuptial agreement, a pre-registration agreement, in fact, is what it's called, before you choose to enter into a civil partnership. And that's significant because, of course, civil partnerships have now been opened up, not just to same-sex couples, but obviously to opposite-sex couples. And so the concept of a prenuptial agreement also applies to a civil partnership.
Okay, thank you very much. Our third question is, when should I begin to discuss the terms of a prenuptial agreement with my partner?
So that's a very difficult subject, because for many people, the thought of entering into a prenuptial agreement isn't the most romantic thing. And once you've got engaged, there are many other more romantic things to be thinking about. But it does make sense to broach the subject sooner rather than later, because one of the conditions that generally need to be fulfilled for an agreement to be persuasive is that the agreement is entered into at least 21, if not 28 days before the ceremony. And there's usually some toing and froing between lawyers, because you each have to have a separate lawyer. And that takes some time, and the drafting can be, there can be details in the drafting that needs to be agreed. So generally, it's a good idea to be thinking about raising the subject, maybe sort of 2 or 3 months at least before the ceremony. That gives you an opportunity to broach the subject, and if an agreement is to be entered into, for one to be drafted and for it to be agreed between lawyers on both sides, we're in good time for that 21, 28 day time. So it's generally good to do it sooner rather than later. It can seem a difficult thing to raise, but generally, because the purpose of an agreement is to avoid any dispute and acrimony and heartache in the unlikely event that a relationship comes to an end, that's generally quite a good way of selling the concept of an agreement. And it's important, I think, to raise it in conceptual terms rather than detailed legal terms with your partner, to see if there is an agreement that such a document should be completed.
Okay, thank you very much. Our fourth question is, will I have to go to court? What is the process?
So you won't have to go to court to complete a prenuptial agreement. Prenuptial agreements are negotiated between lawyers. What you will need to do is to sign the document as a deed because if it's not signed as a deed, it won't be quite so persuasive. And the document simply has to be executed, therefore, in the presence of an independent adult witness, so someone who's not related to you. But you don't have to go to court, and the document doesn't have to be registered with the court after it's been completed. The physical hard copy is, and it's usually done in 2 identical parts, need to be kept somewhere, and usually one party has a hard copy each, and also a copy, an electronic copy, usually needs to be retained. But there's no judicial process or court process that's required in order to complete a prenuptial agreement.
Okay, thank you very much. Our next question is, are prenuptial agreements legally binding?
This is a very good question, and a question that obviously we are asked on many occasions. The answer is no, they're not automatically and completely legally binding, but they can be very persuasive. And in certain conditions, the case law, so the way in which the courts interpret the statutory law, the Act of Parliament, the case law shows that the courts will be keen to adhere to the terms of an agreement, if at all possible, provided certain conditions have been fulfilled. That's probably worth going through those conditions now. And the first is that the document should be entered into at least 21, if not 28 days before the ceremony. The second is that each party should obtain, or at least have the opportunity of obtaining, independent legal advice upon the terms of the document. The third thing to bear in mind is that each party should provide full and frank financial disclosure, and that's usually done by way of attaching a schedule to the document. It doesn't have to be detailed forensic disclosure, but it does have to be a page summarising in ballpark figures and headline figures what each party's capital and income resources are. The fourth point that's important to bear in mind is that neither party should be pressurised to enter into the agreement, and neither party should have what in legal terms is called duress brought to bear upon them to enter into the agreement. And the fifth point to bear in mind is that the agreement must not give rise to any manifest unfairness. So the general principle, the principles that have been established by the case law surrounding prenuptial agreements is that provided parties enter into the document freely, understanding what they're entering into and understanding the effect that entering into that document would have upon their financial claims, and provided they're not pressurized to do it, and provided the effect of the agreement does not give rise to any serious unfairness, then the courts will be reluctant to interfere with the terms of an agreement. Now that's the current status of the law as it stands. 11 years ago, the Law Commission drew up a consultation paper and proposed the possibility of some draft legislation, so that's an act of Parliament, that might actually be introduced at some point in the future to make agreements fully enforceable and automatically binding. So at present, the way in which they are taken into account, prenuptial agreements, is that the courts decide how much weight to attach to them in interpreting the existing law, statutory law, the 1973 Act. The Law Commission envisaged the possibility of a new Act of Parliament coming in that might make those agreements fully enforceable. Now, we don't know whether that legislation will ever be adopted by any successive governments, but the draft legislation did envisage that for an agreement to be a qualifying agreement, so for it to be fully enforceable, if the law ever did change in the future, those same 5 conditions would need to be fulfilled. So those 5 points that we've just discussed are a very good indicator of whether the courts are likely to regard an agreement as being persuasive at present, and also a very good indicator of what requirements might need to be fulfilled if the law ever changes in the future to make them fully enforceable.
Okay, thank you very much. Our next question is, what sort of disclosure would I have to provide? Will I have to include everything, even assets not in the UK?
So that's a very good question, because of course full and frank financial disclosure is one of the conditions that need to be fulfilled to enable the courts to place reliance upon an agreement. It doesn't have to be forensic, detailed, documentary disclosure, but it does have to be accurate disclosure in summary form. And it does have to be disclosure of everything wherever it is situated in the world. So the parties can't be selective about what they decide to disclose. And whilst they don't have to get detailed, expensive valuations of assets, they do nonetheless have to attach to the agreement a schedule that accurately summarizes both their capital and income resources. And if, for example, they're expecting to inherit something at some stage in the future, it would be helpful to document in the agreement if and when any inheritance is likely and what sort of size that inheritance would be. Because it would be very helpful to confirm the context in which that agreement was completed. So not just disclosing the assets that you have, but also the assets that you believe you might have by way of inheritance at some point in the future.
Okay, thank you very much. Our next question is, what should we do if we're not getting married in the UK?
That's a good question, because people lead increasingly international lives, and prenuptial agreements often have to apply in a number of possible jurisdictions, by which we mean legal systems. So it's not unusual for parties to get married in one country and to live in another country. There are two aspects to think about if you're planning to get married in a different country to where you're going to live. Firstly, you need to fulfill the marital requirements, the procedural requirements of the country in which you're getting married. So if, for example, you get married in France, it's usual to ask the public official who conducts the ceremony or registers the ceremony to identify whether you've chosen to select a marital property regime. That is a system that governs the way in which you hold your assets during the marriage and in the event of your marriage coming to an end. So, for example, if you were to enter into a prenuptial agreement and get married in France, you'd need to make sure that a translation of that document was registered with the town hall or the notary or the public official, and that you have selected the right marital property regime when you get married. That's not a difficulty in England, because English law doesn't recognise marital property regimes. And what you do have to think about is, where are you likely to be in the future? Where are you going to live in your marriage? Because where you can get divorced in the unlikely event your marriage comes to an end will not depend upon where you were married, but what your circumstances are at the time your marriage breaks down. And most countries have a residence requirement or a nationality or domicile, in the case of England or Ireland, requirement. And it's possible for more than one country to have what we call jurisdiction at the time the marriage comes to an end. So if, for example, two French nationals marry and they enter into a prenuptial agreement and they are living in England at the time, it would be possible under the Brussels legislation, the European conventions that govern international cases, for them to get divorced in France on the basis of their both having the same nationality, in addition to England if they're both residing in England at the time their marriage comes to an end. So the international aspects of prenuptial agreements become quite complex, because not only may you have more than one country available in which to get divorced, but there may be a difference in the way in which prenuptial agreements are treated by the legal systems of those countries. So it's generally worth taking specialist advice at the time you do your prenuptial agreement to work out whether you need to do a mirror agreement. That's an agreement that would make the prenuptial agreement fully enforceable in accordance with the legal system of another country if you were to get divorced there, or to form a view about whether there's any likelihood of your living abroad and whether you need to think about the international aspects of the agreement. It is complicated, and it is important to get it right. So to answer your question, what should we do if we're not getting married in the UK? Firstly, check the procedural requirements of the country in which you're getting married. And secondly, get specialist advice from a family lawyer about whether you need to include extra clauses in that prenuptial agreement, or whether you in fact need to do an agreement in another country as well.
Okay, thank you. That's very helpful. Our next question is, we already have a child or children together. How might they factor into drawing up a prenuptial agreement?
Now that's a good question, because the leading case the Supreme Court judgment, the 2010 judgment, Granatino and Radmacher, is the case which establishes those 5 fundamental points we've discussed earlier. But it does make it clear, that case, and subsequent cases have made it clear, that the court can always depart from the terms of an agreement if it's necessary to provide for children. The basic principle behind that is that it is not acceptable, nor indeed possible, for a parent to contract out, if you like, of any claims that their children might have. And typically those claims are income, maintenance for children until they reach the age of majority or complete their education, and sometimes capital sums that are required for children, and sometimes the provision of a home until children reach the age of majority. So if you already have a child or children together, it would be sensible to ensure that the agreement provides financially for them. But if it does not, the court can still, in any event, separately of its own volition, make financial provision for children, irrespective of what the agreement says. The one thing that the agreement generally cannot do is decide what arrangement should apply for that child, so with whom that child should live and how much time they should spend with the parent with whom they do not live. The reason for that is that that will depend upon the circumstances at the time, and there's a whole separate piece of legislation that enables the court to consider arrangements, so not financial arrangements, living arrangements for children. But the court can certainly make separate financial provision for children in any event.
Okay, thank you very much. I think our next question is, we are already married. Is there any way to draw up a similar agreement?
Yes, there is. And the agreement that would be appropriate in that case would be what's called a post-nuptial agreement. And that is obviously, the principle is the same as a prenuptial agreement, but of those 5 conditions, the first one obviously would not apply because it's an agreement that's entered into after marriage, and therefore the 28-day requirement to enter into the document 28 days before the ceremony does not apply. But the other 4 points will still apply when the courts interpret whether postnuptial agreements should be persuasive and should affect the outcome of the division of assets in the event of breakdown of marriage. Typically in postnuptial agreements, the court becomes quite concerned about the duress point, and that becomes quite an important factor. Because if, for example, a party is led to believe that there will be a divorce unless they enter into a postnuptial agreement, then that might undermine the validity of the agreement in due course. But as a concept, postnuptial agreements would apply. You can enter into them once you're already married. It's the 2nd, 3rd, 4th, and 5th of those points we identified earlier that the court would be concerned with. And there is an authority, there is a case that establishes that postnuptial agreements can also be treated in the same way as prenuptial agreements, except where they're entered into after parties have been married. It's interesting to note that the draft legislation that the Law Commission proposed 11 years ago did envisage that postnuptial agreements might also be a qualifying agreement if the law ever changes in the future. So in theory, the principles are extendable also to postnuptial agreements.
Okay, thank you very much. Our next question is, what if our financial circumstances change significantly later on? Will the court make us uphold the agreement in the event that we divorce?
So the answer to that question is the court could, or it might not. It all depends on whether it gives rise to any manifest unfairness. The difficulty about that 5th point, manifest unfairness, is that in order to work out whether something is unfair, you need to compare it against what someone would receive if they hadn't entered into the agreement. And one of the factors that the court takes into account when considering how to divide assets upon a divorce is how long has the marriage lasted? Have all these assets been built up during the marriage? So it's possible that if the parties' financial circumstances change significantly later on, that the court might regard the effect of the agreement as being manifestly unfair. It all depends on the parties' circumstances at the time the marriage comes to an end. How long has the marriage lasted? What assets have been built up? Is the provision set out in the prenuptial agreement really, really unfair? And would the court want to depart from it? Now, sometimes people want to guard against that possibility, and sometimes prenuptial agreements provide for the opportunity for a review. So, for example, after 5 years or 10 years, the parties can consider whether they review that agreement and enter into a subsequent agreement that might change the provision. That's always a possibility, and sometimes people like to structure their agreements in that way to try to maximize the opportunity of not falling foul of that fifth condition, which is that entering into an agreement which years down the line seems manifestly unfair because people's finances have changed significantly later on.
Okay, thank you very much. Our final question is, what should I do if a partner tries to pressure me into signing a prenuptial agreement?
Well, it all depends on what the effect of that agreement would be. But generally, if the effect of the agreement would be unfavourable, then obviously you should not enter into a document that you don't want to enter into. And because one of the conditions, there's 5 conditions, is that duress should not be brought to bear upon a party, it's unlikely that the agreement would be enforceable in any event or even highly persuasive. So the first answer would be don't sign anything you don't want to sign. And secondly, if you are signing it under duress, it's very important that you have some evidence of that, so that when the court considers how much weight to attach to the agreement, it's clear that the 4th condition has not been fulfilled because someone is signing it under protest or under duress. But it would be better not to sign the document at all.
Okay, thank you very much for your time today. Those are all of our questions, and we very much hope that this has been useful if you are considering a prenuptial agreement with your partner or your fiance. Thank you for your time, Neil. And that brings our
Thank you very much, Sarah.
No, you're very welcome.
Thank you. Goodbye.
Thank you. Goodbye.